Before we begin, please note that the information in this video is for educational and informational purposes only. It reflects personal experiences and industry observations and should not be considered legal, financial, or career advice. There are no guarantees of admission to any school, employment at any firm, or specific salary outcomes. Your own journey will depend on your individual circumstances, efforts, and the market conditions at the time. The starting salary at America's top corporate law firms just crossed $225,000. That's for a 25-year-old straight out of law school. Add in the bonus and you're looking at $250,000 in your first year. It's a staggering number. It's the number that fuels the entire pre-law industrial complex. It's the number that makes intelligent, ambitious people grind through college, study for 1,000 hours for a single test, and take on 6 figures of non-dischargeable debt. They're all chasing that number. But here's the terrifying secret that nobody puts in the glossy law school brochures. The vast majority of people who go to law school will never, ever see that number. Not even close. They'll follow the rules. They'll get a good GPA. They'll crush the LSAT. They'll get into a great law school. And then somewhere along the way the path just disappears. They find themselves on the outside looking in, wondering how a handful of their classmates landed these life-changing jobs while they're sending out hundreds of resumes into a void. They played the game they were told to play, but they didn't realize they were playing the wrong game entirely. Because becoming a top corporate lawyer isn't a checklist. It's not a meritocracy in the way you think it is. It's a highly sophisticated, multi-year campaign. And for the next hour, I'm going to give you the playbook. I'm going to expose the hidden steps, the unwritten rules, and the subtle signals that separate the candidates who get the offers from the ones who get the rejection letters. This isn't the advice your college pre-law advisor gives you. This isn't what you'll learn in your law school's career services office. This is the insider's guide. We're going to dismantle the entire process from your freshman year of college to the day you accept that offer, and show you how to build the perfect candidate profile step by painful step. We're going to solve the single biggest problem aspiring lawyers face: how to navigate a system that is designed to be opaque. So let's start by destroying the first and biggest myth. The myth that your journey begins with the LSAT. Everyone, and I mean everyone, thinks the LSAT is the great gatekeeper. That a high score is the golden ticket that opens every door. And it is important. But focusing on it as the starting line is like a marathon runner thinking the race starts at mile 20. The real race, the one that the winners are running, starts years before you even buy an LSAT prep book. The true first hidden step to becoming a corporate lawyer is this. You must stop thinking like a student trying to get into law school, and start thinking like a law firm recruiting committee trying to hire a first-year associate. Let that sink in. The game is not, how do I get into the best law school? The game is, how do I 3 to 4 years from now become the most compelling, lowest risk, highest upside hire for a multi-billion-dollar business? Because that's what a major law firm is. It's a business selling an incredibly expensive product, elite legal advice. And they are pathologically risk-averse. They want a specific type of person, a person who signals through every line on their resume that they are a thoroughbred, that they have the intellectual horsepower, the grit, the polish, and the commercial awareness to perform at the highest level from day one. Your entire pre-law school life is about building a dossier of evidence that proves you are that person. The law school you attend is just one piece of that evidence. A very important piece, but still just one piece. So what does this actually mean for you right now, whether you're a college freshman or a professional thinking about a career change? It means your major matters, but not for the reason you think. The classic advice is major in whatever you want, just get a high GPA. This is dangerously incomplete. Yes, a high GPA is non-negotiable, but a 3.9 in political science from a state school and a 3.7 in electrical engineering from MIT do not send the same signal. Law firms don't care if you know political theory. They care about signals of rigor and analytical ability. A STEM degree, a hard economics or finance degree, a philosophy degree that required formal logic, these signal to a recruiting committee that you can handle dense, complex, rule-based systems. That's all corporate law is. It's not about grand speeches in a courtroom. It's about mastering 1,000-page bond indentures. If you can handle differential equations or deconstruct Kant, you can probably handle the Securities Act of 1933. It's a proxy for raw intellectual horsepower. If you're already a humanities major, that's fine. But you need to find other ways to signal that quantitative rigor. Take the hardest classes in your department. Write a thesis that involves complex research. Don't just get an A. Get an A in a way that screams, "I am a serious intellectual." Next, your work experience before law school. This is probably the most undervalued asset in the entire process. The traditional path is to go straight from undergrad to law school, K through JD they call it. For a certain type of elite applicant this works, but for most it's a missed opportunity. Working for 2 to 4 years in a relevant high-performance field before law school can be the single greatest differentiator you can have. And I don't mean working as a paralegal at a local law firm. That's what everyone does. It's predictable. It signals you're interested in law, but it doesn't signal excellence in a competitive, commercial environment. Think about the signals again. What does a recruiting partner at a New York firm want to see? They want to see someone who has already succeeded in a demanding professional culture. 2 years as an analyst at Goldman Sachs or McKinsey. 3 years in a highly technical role at a FANG company. Working for a prestigious government agency or a well-known nonprofit. This kind of experience does 3 things. First, it gives you a narrative. You're not just a student who likes to argue. You're the finance professional who understands how deals are structured and now wants to paper them. You're the software engineer who understands intellectual property from the creator's side and now wants to protect it. You have a why. Second, it de-risks you as a hire. It proves you can handle 60-hour work weeks, difficult bosses, and high-pressure deadlines. You've been tested in the real world. And third, it gives you a commercial instinct that a 24-year-old who has only been in a classroom simply cannot have. You understand how businesses think. This is invaluable. A law firm doesn't have to teach you basic professionalism. You already have it. Even your extracurriculars need to be viewed through this lens. Are you just a member of the pre-law society? Or did you found the university's investment club and grow its portfolio by 20%? Did you just volunteer at a soup kitchen? Or did you manage the logistics for the entire operation, securing donations and optimizing volunteer schedules? One shows participation. The other shows leadership, initiative, and a quantitative, results-oriented mindset. Law firms are partnerships. They are looking for future leaders and business generators, not just competent employees. Your college activities are the earliest possible evidence of that potential. Every choice you make, your major, your summer internships, the jobs you take, the way you spend your free time, is a brick in the wall of your candidacy. And you need to be the architect. You have to ask yourself with every decision, what signal does this send? How does this piece of evidence support my case that I am a low-risk, high-upside investment for a top-tier global enterprise? This is the real first step. It's a profound mindset shift. It's to stop seeing college in your early career as a prelude to your legal journey, and to start seeing it as the foundation. You are building your closing argument for why you deserve a seat at the table, and you start building it the moment you step on a college campus. Most of your competition will only realize this during their first year of law school, when they're frantically trying to build a resume from scratch. By then, for many of the best opportunities, it's already too late. You, on the other hand, will have spent years meticulously crafting a profile that is undeniable. A profile that makes the law school application a formality, and the job interview a coronation. So now that we've established this foundation, this new way of thinking, how do we translate it into the next phase? How do we take this meticulously crafted profile and weaponize it for the law school admissions process itself? Because even with the perfect background, you still have to get through the gatekeepers. And that means confronting the two big monsters, the LSAT and the personal statement. And just like everything else we've discussed, the conventional wisdom on how to approach them is almost entirely wrong. Let's start with the LSAT. The biggest lie you've been told is that it's an intelligence test, that it measures some innate, unchangeable reasoning ability. This is a myth perpetuated by test prep companies who want you to feel overwhelmed and by people who did well and want to feel like geniuses. The truth is far more liberating. The LSAT is not an IQ test. It is a skills test. More specifically, it's a fluency test. You are learning a new language, the language of formal logic. And just like any language, you don't become fluent by cramming vocabulary the night before. You become fluent through deliberate, focused immersion. The conventional wisdom says to take as many timed practice tests as possible. Grind. This is the single worst piece of advice you can get. It's like trying to learn Spanish by repeatedly taking a final exam without ever studying the grammar. You'll just reinforce your own mistakes. The secret to the LSAT isn't doing more. It's reviewing better. The top scores, the 170-plus crowd, don't just take a test, check their answers, and move on. They perform an autopsy. For every single question they got wrong, And even the ones they got right but weren't 100% sure about, they spend 15, 20, even 30 minutes deconstructing it. They ask, what was the logical flaw in my thinking? What specific trick or pattern did the test makers use to bait me into this wrong answer? What fundamental concept of logic did I misunderstand? They create a wrong answer journal, and over time they see the patterns not just in the test but in their own thinking. They stop making the same mistakes. That is how you build fluency. Let's break it down. The logic game section, the part that terrifies everyone, is actually the most learnable part of the entire test. People think it requires some kind of superhuman Sudoku ability. Doesn't. It requires an unshakable commitment to diagramming. Every game is a self-contained universe with a fixed set of rules. Your job is not to solve it in your head. Your job is to translate those rules into a visual system, a master diagram that reveals all the possible solutions. Once you have a bulletproof diagramming method for each type of game, the questions become almost trivial. It's no longer a logic puzzle. It's an act of reading a map that you yourself have drawn. Then there's logical reasoning, which makes up half the test. This is the heart of the LSAT and the core of legal thinking. Every single one of the 50 or so questions in this section is built around one thing: the gap between the evidence presented and the conclusion drawn. Your job is to be a professional skeptic. You are a detective examining an argument. Is the evidence sufficient? Does the conclusion necessarily follow? What is the author assuming to be true to make their argument work? Most people read these little paragraphs for content. Elite scorers read them for structure. They aren't getting caught up in whether the topic is dinosaur bones or corporate tax policy. They are identifying the building blocks. This is the premise, this is the conclusion, and here is the unstated assumption holding the whole fragile thing together. Once you can see that gap, you can answer any question they throw at you, whether it's to strengthen the argument, weaken it, or find the flaw. Finally, reading comprehension. Again, the conventional wisdom is a trap. It tells you to read faster. So people try to speed read dense passages about judicial philosophy or quantum mechanics, and they absorb nothing. The secret isn't speed, it's structure. You are not reading for information. You are reading for the author's purpose. Before you even get to the first question, you should be able to answer, why did the author write this? Are they arguing a point? Comparing two theories? Explaining a historical event? You need to create a mental map of the passage, noting where the author introduces their main point, where they provide evidence, and where they address counterarguments. You're not a student memorizing facts. You're an analyst mapping out a line of reasoning. Mastering the LSAT isn't about being the smartest person in the room. It's about being the most disciplined. It's about treating the test not as an enemy to be conquered with brute force, but as a system to be decoded with precision. And once you've decoded that system, you have your score. That number, along with your GPA, forms the what of your application. It's the hard data, but it's only half the story. The other half, the part that breathes life into the numbers, is the why. And that comes from your personal statement. This is where the second set of terrible advice comes in. You'll hear people say you need a gimmick, a hook, a dramatic story of overcoming some incredible tragedy. An admissions officer at a top 3 law school once told me they are so tired of reading what they call the holy trinity of personal statements: the mission trip essay, the dead grandparent essay, and the sports injury essay. It's not that these experiences aren't profound and life-changing. It's that they've become cliches. They're often used as a shortcut to signal virtue or resilience without doing the hard work of connecting that experience to a future in law. The goal of your personal statement is not to make an admissions officer feel sorry for you. The goal is to create a narrative of inevitability. You need to connect the dots of your life, your experiences, your academic interests, your work history, your passions, and present a story so compelling that the admissions officer finishes it and thinks, Of course this person is applying to law school. It is the only logical next step in their journey. Your entire life shouldn't be about law. That's boring and one-dimensional. But you need to find the thread that runs through your diverse experiences and ties them together, pointing directly toward a legal career. Maybe you majored in art history, but you wrote your thesis on the legal battles over repatriating stolen art. Maybe you worked in tech, but you became fascinated by the privacy law implications of data collection. Maybe you were a server in a restaurant, but that experience taught you how to de-escalate conflict and understand contract-like social obligations in a high-pressure environment. Don't just tell them you're hardworking. Tell a 2-sentence story about the time you balanced a 20-credit semester while working 30 hours a week to support your family. Don't just say you're passionate about justice. Describe a specific time you stood up for someone who was being treated unfairly, and analyze what that taught you about systems and power. Show, don't tell. Your personal statement is your one chance to speak directly to the committee. Don't waste it by rehashing your resume in paragraph form. They've already read your resume. This is your chance to give them the connective tissue, the motivation, the why behind all those bullet points. Your story should subtly answer two questions without ever asking them directly. Why law? And why me? It should demonstrate a mature understanding of what a legal career actually entails. Not the Hollywood courtroom drama, but the rigorous analysis, the meticulous research, the adversarial yet collaborative nature of the work. And it must be authentic. Your voice has to come through. This isn't an academic paper. It's a story. Your story. By combining a decoded LSAT score with a compelling narrative of inevitability, you transform from just another applicant into a candidate. You've given the admissions committee both the head and the heart, the analytical horsepower proven by the numbers, and the purpose-driven vision proven by your story. You've made it through the gates. But this is where the real high-stakes game begins. Because now you have to choose a school. And most people make this decision based on one thing: the U.S. News and World Report rankings. They see a number next to a name and assume that a number 8 school is definitively better for their career than a number 12 school. This is a catastrophic, multi-$100,000 mistake. The real calculus of choosing a law school is a hidden game of regional power, alumni networks, and financial arbitrage that the rankings completely obscure. And here's how that game is played. Forget the national rankings for a moment and think about legal markets. The United States isn't one giant legal market. It's a collection of powerful, fiercely loyal, and often insular regional markets. New York, Chicago, and LA are the big ones, sure. But there are incredibly lucrative and powerful legal hubs in Houston, Atlanta, Boston, Dallas, and the Bay Area. And in each of these hubs, there is almost always a local law school that punches far, far above its U.S. News weight class. This is the concept of the regional powerhouse. Let's take the University of Texas at Austin. It consistently hovers around the bottom of the T14 or just outside it. But if you want to work in Texas, a state with a GDP larger than most countries and a legal market to match, a degree from UT is golden. The biggest, most profitable law firms in Houston and Dallas are saturated with UT alumni. They run the hiring committees. They are the senior partners. They see a UT law degree on a resume, and they see one of their own. They know the curriculum, they trust the professors, and they feel a tribal loyalty. For a top student at UT, getting a six-figure job at a Vinson & Elkins or a Kirkland & Ellis in Texas is not just possible. It's the default path. Now, compare that to a student who gets into, say, Georgetown, ranked higher nationally. They go to DC, pay a fortune in tuition and living expenses, and find themselves as a median student in a sea of other brilliant, ambitious people. When it comes time for on-campus interviews, they're competing with the top of their class for DC jobs, and they're at a disadvantage for Texas jobs compared to the UT grad. The Texas firms will fly a few top Georgetown students down for interviews, but they will interview hundreds of UT students on their own campus. The numbers are just stacked against you. The regional powerhouse graduate has the home field advantage, and in the legal world, that advantage is everything. This same dynamic plays out across the country. Emory and Vanderbilt in the Southeast, Boston College and Boston University in New England, USC and UCLA in Southern California. These schools are kingmakers in their respective domains. A top student from one of these schools has a significantly better chance of landing a top-tier corporate law job in their home market than a median student from a slightly higher-ranked school who is seen as an outsider. The alumni network isn't just a social club. It's a high-powered private employment agency that you pay $250,000 to join. Choosing a school that makes you a member of the right club for where you want to live and work is the first secret move that the rankings don't show you. But the second, and arguably more important move, is the financial one. This is where you can truly set yourself up for success or for a decade of misery. Big law firms are acutely aware of the rankings and this regional dynamic. So here's what they do. The T14 schools know they can charge sticker price, close to $80,000 a year, because students are desperate for the brand name. But that T25 regional powerhouse? They're in a fight. They need to attract the best students, especially those who also got into the T14. And their weapon is money. Lots of it. This creates the single most important opportunity for a prospective law student: the scholarship arbitrage. Let's create a hypothetical student, Sarah. Sarah has a great LSAT score and GPA. She gets into Cornell, a T14 school, but with no scholarship money. Total cost of attendance over 3 years, around $300,000. She also gets into Vanderbilt, a T20 school, but they offer her a full tuition scholarship. Her total cost, just living expenses, maybe $90,000. The U.S. News ranking tells her to go to Cornell. It's the better school. This is the trap. This is where so many brilliant futures are mortgaged. Sarah, if she's smart, ignores the rankings and takes the money at Vanderbilt. Why? Because the outcome is nearly identical, but the financial freedom is life-altering. Let's play it out. Top law firms use a crude filter for hiring first-year associates. For a T14 school like Cornell, they might say, "We'll interview anyone in the top 50% of the class." For a T20 school like Vanderbilt, they might adjust that and say, "We'll interview the top 33%. So yes, the bar is slightly higher at Vanderbilt to get the same interview. But here's the secret. It is monumentally easier to be in the top third at Vanderbilt than in the top half at Cornell. You are competing against a slightly less credentialed student body. You are a bigger fish in a slightly smaller, but still very prestigious pond. The odds of you excelling and hitting that top 33% are much higher. So Sarah goes to Vanderbilt. She works her tail off, finishes her first year in the top 25% of her class, and gets her pick of interviews with the top firms in Atlanta, Nashville, and even New York. She accepts a job at a firm like King & Spalding or Alston & Bird. Her starting salary is $225,000 a year. The Sarah who went to Cornell? Let's say she was a median student. She also gets a job at a great firm in New York for the exact same starting salary. From the outside, their careers look identical. Both are first-year associates at elite corporate law firms. But their lives are completely different. The Cornell Sarah has a $300,000 anvil of debt hanging around her neck. With interest, this can easily become a $400,000 debt. Her monthly student loan payment is thousands of dollars. It will be for 10 to 15 years. She has to stay in big law whether she loves it or hates it. She can't afford to leave to join a startup, work for the government, or start her own practice. She is trapped. Her prestigious job is just that, a job, one she needs to service a crushing debt. The Vanderbilt Sarah? She has a fraction of that debt. Her monthly payments are manageable. After 2 or 3 years of making a massive salary, she could be completely debt-free. The world is her oyster. If she loves big law, she can stay and become a partner. If she discovers she hates the 80-hour work weeks, she can leave. She can take a massive pay cut to take her dream in-house counsel job at a tech company. She can move to a smaller city for a better quality of life. She has options. She has freedom. That scholarship didn't just save her money. It bought her the right to choose her own future. This is the calculus. The goal isn't just to get the big law job. It's to get the job on terms that give you power and flexibility over your own life. Sacrificing a few ranking spots for a massive scholarship at a strong regional school that places well into your target market is the single most strategic, life-altering decision you can make. It is the cheat code to winning the game before it even starts. Because once you've made your choice, once you've sent in that deposit and packed your bags for law school, the board is set. And your entire career, every opportunity you will ever have, will be defined by what you do in the next 9 months. The first year of law school, the 1L year, isn't just another year of school. It's a brutal, high-stakes tournament where the winners are decided long before the final exam. The grades you get in your first year will follow you for the rest of your life, opening or closing doors with a finality that is terrifying. And the way to win that tournament has almost nothing to do with what made you successful in college. It's a completely different game, with a hidden rulebook that most students only discover after it's too late. The first rule of this hidden rulebook is the most important, and it's the one that breaks the most people. Your entire first year of law school, the year that determines your entire career trajectory, is not graded on your effort, your intelligence, or how much you learn. It is graded on a forced mandatory curve. This isn't like college where if everyone does great work, everyone can get an A. In law school, the professor is required to give out a specific, predetermined number of A's, B's, C's, and sometimes even D's. The class is a zero-sum game. For you to get an A, someone else must get a lower grade. Your success is mathematically tied to the failure of your peers. The people sitting next to you, the ones you study with, the ones you grab a coffee with, they are not just your colleagues, they are your direct competitors in a brutal forced ranking system. This isn't an exaggeration. It's the literal mechanical structure of the 1L grading system at almost every top law school in the country. It turns a collaborative learning environment into a silent, psychological tournament. And the only thing that matters in this tournament is your final grade. Which brings us to the second hidden rule. 100% of your grade in almost every core 1L class comes down to a single 3-hour exam at the end of the semester. Think about that. No homework assignments, no quizzes, no midterm, no participation points. You will spend 4 months reading thousands of pages, briefing hundreds of cases, and sitting through hours of lectures, and none of it will be graded. You get zero feedback on your progress. You have no idea if you're on the right track or completely lost. You are flying blind in a blizzard for 14 weeks, and then you are dropped into a single high-stakes exam that will determine your entire future. It's a system designed to create maximum pressure and expose any crack in your preparation. So if the final exam is all that matters, what about the thing everyone fears most about law school? The Socratic method. The terrifying cold calling where the professor puts you on the spot in front of 200 people and grills you on a 17th century property law case. This is hidden rule number 3, and it's a mind-bender. The Socratic method is a ghost. It's a theatrical performance designed to scare you into doing the reading, but it has almost nothing to do with your final grade. Students waste hundreds of hours over-preparing for class, terrified of being embarrassed. They spend 3 hours meticulously reading and briefing a single case, preparing for every possible question the professor could ask. They walk into class heart-pounding, and when their name isn't called, they feel a wave of relief. But here's the secret. The student who gets called on and brilliantly dissects the case gets the exact same grade as the student who sits in the back, silently figuring out the bigger picture. The Socratic method is a tool for the professor to guide a discussion, but it is not the test. Focusing on it is like a boxer training for a title fight by only practicing his walkout music. It's performance, not preparation for the actual battle. The real work, the work that gets you in a, happens entirely outside that classroom. So what is that work? If it's not about acing the cold calls, what is it? This leads to the fourth and most crucial hidden rule. You are not in law school to learn the law. That sounds insane, but it's true. No one expects you to memorize every rule and statute. In fact, most law school exams are open book. You can bring all your notes, all your books, anything you want. The test isn't about what you know. It's about what you can do with what you know in a ridiculously short amount of time. You are being trained for one specific skill. Issue spotting. That's the secret language. A typical law school exam gives you a long, convoluted story, a fact pattern, about a ridiculous series of events. A man is building a fence, his neighbor's dog digs under it. The man gets angry and throws a cursed garden gnome at the neighbor, who dodges, and the gnome flies through the window of a passing car, causing the driver to swerve and hit a truck carrying a shipment of priceless, uninsured Fabergé eggs. Your job is not to say who wins. Your job is to read that chaotic mess and, like a legal surgeon, identify every single potential legal conflict. That's an issue. The fence is a potential property dispute. The dog is a potential tort of trespass to chattels. The cursed gnome is a potential assault. The broken window is negligence. The Fabergé eggs bring up damages calculations. Your final exam is a race against the clock to spot as many of these issues as possible. And then for each one, apply a rigid logical framework. It's called IRAC, Issue Rule Application Conclusion. You state the issue you spotted. You state the legal rule that governs it. You apply that rule to the specific facts from the story. And you write a short conclusion. That's it. That's the whole game. The person who gets the A is the person who can spot the most issues and analyze them using that framework faster and more thoroughly than anyone else in the room. This is why your college study habits are useless. In college, you study to understand and remember. In law school, you study to build a weapon. And that weapon has a name. It's called an outline. And mastering its creation is the final and most closely guarded secret of the first year. The entire semester isn't about going to class or reading the books. It's a 4-month-long project to construct a perfect, personalized attack outline for each course. This document is your real work product. It's a roadmap that synthesizes every rule from every case, every lecture, every reading, into a logical, weaponized checklist designed for one purpose: to tear apart that final exam fact pattern faster than your competitors. While everyone else is rereading the textbook or briefing cases for the next cold call, the A students are spending their time building this document. They're not just summarizing, they're synthesizing. They're turning 1,000 pages of dense text into a 30-page, hyper-organized playbook. It's the difference between showing up to a sword fight with a pile of scrap metal versus a perfectly forged, balanced, and sharpened blade. The person with the outline doesn't need to think during the exam. They just need to execute. So now you see the hidden architecture. The game is a tournament called The Curve. The final battle is a 3-hour issue-spotting exam. The daily classroom theatrics are a distraction. And the key to victory is a secret weapon you must build yourself piece by piece over 4 months. But knowing this is one thing. Actually building that weapon, creating an outline that can dismantle the exam and place you in the top 10% of your class, is an art form in itself. There are specific techniques, specific structures, and common mistakes that separate the outlines that get A's from the ones that get B's. And that's the next secret we need to unlock. The single biggest mistake first-year law students make is treating their outline like a study guide. They think its purpose is to be a comprehensive summary of the course. So they spend hundreds of hours transcribing their notes, retyping textbook chapters, and color-coding every case brief into a monstrous 100-page document that is utterly useless. It's a security blanket, not a weapon. An A-level outline is not a summary of what you've learned. It's a blueprint for the final exam. That is the entire secret. Every single word, every single case, every single policy argument in your outline should be there for one reason and one reason only: to help you get points on the exam. Think of it this way. The average law student is a historian. They are meticulously documenting everything that happened in the class. On September 15th, we discussed Penhoy Vanef, and the professor said this: they create a beautiful, detailed record of the past. The top 1% of students are not historians. They are architects of the future. They are building a machine designed to solve a specific problem that doesn't exist yet: the final exam. Their outline is the schematic for that machine. So, how do you build this machine? You stop being a transcriber and you start being a ruthless editor. You build your outline in 3 distinct layers, and you don't move to the next layer until the previous one is perfect. The first layer is the skeleton. This is the pure black-letter law. These are the rules, stripped of all context and commentary. For a contracts class, this would be your main headings: formation, defenses to formation, terms, performance, breach, and remedies. Underneath formation, you would have offer, acceptance, and consideration. Under offer, you'd have the simple definition: a manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that their assent to that bargain is invited and will conclude it. That's it. No cases, no hypotheticals, no professor's rambling stories. Just the raw, unadorned rules of the game. Your goal is to distill an entire semester's worth of doctrine into the leanest possible structure. This skeleton should be no more than 5 to 10 pages long total. It's your table of contents for the entire course, your map of the legal landscape. Most students screw this up by immediately burying the rules in the details of cases. They can't see the forest for the trees. You must build the forest first. Once your skeleton is rock solid, you move to the second layer, the muscle. This is where the cases come in, but not in the way you think. You are not writing case briefs. You are not summarizing the facts. You are extracting the single, precise legal principle that the case adds to the skeleton. Each case you read is a tiny little screw or a gear that modifies one of the black-letter rules. Your job is to identify that modification and plug it into your skeletal outline. For example, you have your black-letter rule for what constitutes an offer. Then you read a case like Leonard v. PepsiCo, the infamous Harrier jet case. The average student will write a long paragraph about the TV commercial, the kid, the Pepsi points, and the judge's witty opinion. The A student will add one single bullet point under their offer rule that says, advertisements are generally not offers, but invitations to treat, unless they are clear, definite, and explicit, and leave nothing open for negotiation. Leonard v. PepsiCo. Boom. Done. You have just weaponized that case. You've turned a 10-page judicial opinion into a 20-word tool that you can deploy on an exam. You do this for every single case. You're not summarizing, you're harvesting. You're harvesting rules, exceptions, and clarifications, and you're bolting them onto your legal skeleton. This muscle layer is what gives the law its texture and nuance. It's where you show you didn't just memorize the rules, you understand how they bend and flex in the real world. Now, if you do these first 2 layers correctly, you'll get a B, maybe a B+. You'll have a solid, functional understanding of the law. But you won't get an A. The A is found in the 3rd layer, the layer almost no one bothers to build. The nervous system. This is the attack plan. This is where you stop thinking like a student and start thinking like a lawyer. For every single rule in your outline, you now add 2 new sections: policy and exam tactics. The policy section answers the question, why does this rule exist? What is the purpose of the mailbox rule? It's about allocating risk. Why do we have the doctrine of unconscionability? To protect vulnerable parties and uphold the integrity of the courts. You need a 1 or 2 sentence summary of the policy behind every major legal doctrine. Why? Because on a law school exam, you'll often face a situation where the rules are ambiguous. The facts fall in a gray area. In those moments, the student who can argue from policy, who can say, the court should rule this way because it aligns with the underlying purpose of the doctrine, which is to promote economic efficiency, that student is operating on a different level. They are not just spotting issues. They are making persuasive legal arguments. That's an A. Even more important is the exam tactics section. This is your prescripted plan of attack. You look at a rule like the statute of frauds and you write out a mini checklist. If I see a contract for the sale of land or over $500, my first step is to check for assigned writing. Step 2 is the writing sufficient? Does it identify the parties, subject matter, and essential terms? Step 3, if there's no sufficient writing, are there any exceptions? Part performance? Promissory estoppel? I will argue them in that order. You are literally building a flowchart for your brain. You're creating triggers. If I see these facts, I will do these 3 things. You do this for every single topic. You anticipate the professor's tricks. You write down common counterarguments. For example, under offer, your tactics might say, argument. This was a valid offer. Counterargument. No, it was mere puffery or an invitation to treat. Use Leonard v. PepsiCo to distinguish. Your finished outline is no longer a passive document. It's an active offensive playbook. It's a series of if-then commands. It's a diagnostic tool and an instruction manual for dismantling any fact pattern your professor throws at you. The final document for a semester-long course might only be 25 to 30 pages long, but every single word is pure, weaponized information. It's dense, it's efficient, and it's built for one purpose: to dominate the final exam. When you walk into that exam room, you're not hoping to remember something you read 3 months ago. You have a system. You see a fact pattern, and it triggers a specific part of your outline's attack plan. You're not thinking, you're executing. While other students are frantically flipping through their 150-page binders trying to find the right case, you are calmly and methodically deploying the arguments and counterarguments you prepared weeks in advance. You are fighting the war on your own terms on a battlefield you designed. This process is hard. It's intellectually demanding. It requires you to constantly ask why and how. It requires you to synthesize, not just summarize. But this is the hidden work that top performance is built on. A brilliant outline is the single most important piece of intellectual property you will create in law school. It's the difference between being a passive recipient of information and an active master of it. But even with the perfect blueprint, the perfect weapon, you still have to know how to use it under the extreme pressure of a 3-hour closed universe exam. Because reading the schematic is one thing. Actually flying the jet is something else entirely. And that's where the art of issue spotting comes in. Issue spotting is the difference between a student who knows the law and a student who can use the law. It's a legal treasure hunt. Your professor hands you a 3-page story, a fact pattern, about a series of unfortunate events involving a hapless character named Bob, a runaway lawnmower, a priceless antique vase, and a poorly worded email. Your job in 3 hours is to read this chaotic story and find every single potential legal claim hidden within it. It's not about finding one answer. It's about finding 20. The professor didn't write that Bob slipped on a banana peel. They wrote that Bob, hurrying to catch a bus, failed to notice a discolored, overripe banana peel lying on the otherwise immaculate floor of the grocery store, which had been freshly mopped by an employee just moments earlier. A non-lawyer sees an accident. A trained law student sees a universe of legal questions. Is the grocery store liable for Bob's fall? What's the legal issue? Negligence. What's the rule for negligence? Duty, breach, causation, and damages. Did the store have a duty to keep its floors safe? Yes, a business invitee is owed the highest duty of care. Did they breach that duty? Well, they mopped, which is good, but did they put up a wet floor sign? The facts don't say, so you have to argue both sides. Was there an employee who should have seen the peel? How long was it there? This is the application. What about causation? Was it the store's breach that actually caused Bob's injury? And what are the damages? A broken leg? Medical bills? Lost wages? And what about Bob's own negligence? He was hurrying. Should he have been paying more attention? That's comparative negligence, a potential defense for the store. You see what just happened? From one sentence about a banana peel, we've just unpacked 5 or 6 distinct legal issues, each with its own set of rules and counterarguments. Now multiply that by a dozen other facts in the story. The runaway lawnmower? That's a potential product's liability claim against the manufacturer, and another negligence claim against the owner. The antique vase it shattered? That brings in property law and the measure of damages for unique chattel. The poorly worded email sent later? That could be an attempt to form a contract to pay for the damages, raising issues of offer, acceptance, and consideration. This is the game, and the framework for playing it is the single most important acronym you will ever learn in law school. IRAC. Issue, Rule, Application, Conclusion. For every single problem you spot, you must analyze it through this lens. First, state the issue. The central question is whether the store was negligent. Second, state the rule. The rule for negligence is duty, breach, causation, damages. You define each of those elements based on the case law you learned all semester. Third, and this is where the points are, the application. You must meticulously connect the facts from the story to the elements of the rule. You can't just say, the store breached its duty. You have to say, the store breached its duty of care because an employee left a banana peel on the floor, creating a foreseeable risk of harm to customers like Bob. You use the facts as your evidence. You become a detective, and the fact pattern is your crime scene. Finally, the conclusion. Therefore, it is likely that a court would find the store liable for negligence. You do this over and over and over again. A great law school exam answer is not one long, flowing essay. It's a highly structured, almost robotic series of IRACs. Issue, Rule, Application, Conclusion. Next issue. Issue, Rule, Application, Conclusion. It's a machine-like process of identifying a problem, stating the governing principle, applying the facts to that principle, and moving on. The students who get B's are the ones who know the rules but can't spot all the issues, or they spot the issues but don't know how to apply the facts properly. The students who get A's are the issue-spotting machines. They see the matrix. They can read a story about a guy buying a sandwich and spot 3 contract law issues, a torts issue, and a potential UCC warranty claim. This skill fundamentally rewires your brain. It's a cognitive transformation that never leaves you. You stop seeing the world as a series of events. You start seeing it as a series of potential legal claims. You can't watch a movie without mentally litigating the car chase scene. You can't read a news article about a corporate merger without spotting the antitrust implications. This might sound exhausting, and sometimes it is, but it's the price of admission. You are training yourself to think in a way that is profoundly different from 99% of the population. You're learning to deconstruct reality into a set of legal rights and obligations. And this isn't just some abstract academic exercise. This is the single most transferable skill you will take into corporate law practice. When you're a junior associate at a big firm, a partner isn't going to come to you and say, "Please write me a memo on the doctrine of promissory estoppel." They're going to walk into your office, throw a 300-page agreement on your desk and say, "Our client is about to sign this. Read it. Tell me if we have a problem." Your job is to be an issue spotter. You have to read that dense, impenetrable document and find the ticking time bombs. Is that indemnification clause too broad? Does that change of control provision get triggered if they sell their European division? Is the intellectual property representation strong enough to protect our client if it turns out the seller didn't actually own the patent to their core technology? You are, once again, hunting for treasure, or in this case, landmines, hidden in a dense forest of text. The law school exam was the simulator. This is the real thing with hundreds of millions or even billions of dollars on the line. The pressure is immense, the stakes are astronomical, but the underlying skill is identical. It's the ability to read a complex set of facts and identify every single legal implication, every risk, every opportunity. That is the core function of a great lawyer. So you spend your first year of law school not just memorizing laws, but mastering the art of the treasure hunt. You do hundreds of practice problems. You join study groups where you argue endlessly about hypothetical banana peels. You learn to structure your thoughts into a relentless logical chain of IRACs. You internalize the process until it becomes second nature. And you do all of this for one reason, the curve. Every first-year class is graded on a mandatory merciless curve. The professor doesn't just decide who gets an A or a B. The school forces them to give out a certain percentage of A's, a certain percentage of B's, and so on. In a class of 100 brilliant, hardworking students who were all at the top of their class in college, only 10 or 15 of them can get an A. You are in a direct zero-sum competition with every single person sitting next to you. And the sole determinant of your rank on that curve is that one 3-hour issue spotting exam at the end of the semester. Your entire grade, your entire future, hinges on your performance in that single high-pressure window. There are no points for effort, no extra credit. You either spot the issues and IRAC them better than the person to your left or you don't. It's a brutal, unforgiving system, but it's designed to forge you into the kind of analytical weapon that big law firms need. It forces you to develop an obsessive attention to detail and an ability to perform under extreme mental duress. Mastering this skill of issue spotting is what gets you the grades. And in the hyper-competitive world of corporate law, those first-year grades are your ticket to the single most important event of your entire legal career. The high-stakes speed dating ritual that will determine whether you land a job that pays over $200,000 a year, or whether you end up wondering why you took on 6 figures of debt in the first place. This is on-campus interviewing, or OCI, and it is the single most important week of your professional life. Forget the bar exam. Forget your final grades. For 99% of aspiring corporate lawyers, this is the gate. Pass through it and your future is practically set. Fail and you're staring down a mountain of debt with no clear path to the summit. Imagine a massive hotel ballroom. The air is thick with a strange mixture of expensive cologne, hairspray, and pure unadulterated anxiety. Hundreds of students, all in their first presentable suit, usually black or navy blue, a little too tight or a little too loose, are clutching leather-bound portfolios like life rafts. They're all trying to look calm, cool, and collected, but their eyes give them away. They dart around the room, sizing up the competition, whispering to friends, "Did you hear who got a call back from Kravitz?" Or, "My Skadden interview was a disaster." Lining the walls and filling the center of this room are dozens of identical, tiny tables. Behind each one sits a lawyer. Not just any lawyer. These are partners and senior associates from the most powerful law firms on the planet. Firms whose names are whispered in law school hallways with a kind of religious reverence. These people bill out their time at over $1,000 an hour, and they've flown in from New York, Chicago, and Los Angeles to spend 3 days sitting in a stuffy hotel, conducting back-to-back-to-back 20-minute interviews. Why? Because they are on a hunt. They're looking for the next generation of legal talent that will fuel their multi-billion-dollar engines. And you are the prey. But you don't just walk up and get an interview. Oh no, that would be far too simple. The process begins weeks earlier with a bizarre and stressful ritual known as bidding. Your law school gives you a set number of points, let's say 1,000. You then use these points to bid on interview slots with the firms you want to meet. It's a market, a high-stakes auction for your own future. If you want to interview with the most prestigious firm, a firm that only takes students from the top 5% of the class, you might have to spend a huge chunk of your points just to get in the room. If you bid too low, you get nothing. If you spend all your points on long-shot reach firms, you might end up with only a handful of interviews. If you play it too safe and only bid on less prestigious firms, you might be leaving a 6-figure salary on the table. It's a brutal exercise in game theory and self-assessment. You have to be brutally honest with yourself about your grades. Are you a top 10% student? Then you can aim for the V10, the 10 most prestigious firms in the country. Are you in the top third? You're still in the game for big law. But you have to be more strategic, targeting firms with larger summer classes or a strong presence in your local market. Your entire strategy is based on that one cold number, your GPA. Let's say your bidding strategy works. You've secured a schedule of 25 interviews over 3 days. That's 25 high-pressure, 20-minute conversations that will determine the trajectory of your career. The bell rings and the gauntlet begins. You walk to your first table, shake a firm hand and sit down. The clock is ticking. You have 20 minutes. The first 5 minutes are pleasantries. The interviewer asks about your summer, you ask about their flight in. It's a dance. The next 10 minutes are the core of the interview. They will ask you 2, maybe 3 substantive questions. They almost always start with, "So, walk me through your resume." This is not an invitation to read your resume aloud. It's a test. They want to see if you can tell a coherent story. A story that goes, "I did this, which led me to this, which made me realize I was interested in this aspect of the law, and that's why I'm sitting here today talking to your specific firm." You need a story. "I want to make a lot of money" is not a story. I've always been interested in business, and during my internship at the SEC, I saw how critical transactional lawyers were to capital formation, which is why I'm so drawn to your firm's market-leading M&A practice. That is a story. Then comes the next question. Why our firm? This is the single most important question you will be asked, and your answer cannot be generic. You can't say, because you're a great firm with a global presence. Every firm is a great firm with a global presence. You have to be specific. You need to have spent hours on their website reading about their recent deals, looking up the specific practice group in the office you're interviewing for. You need to know the name of a partner in that group and a deal they worked on. You need to say something like, I was particularly interested in the work your technology transactions group did on the recent acquisition of Cloud9 Incorporated. The cross-border data privacy issues in that deal are fascinating to me, and it's the exact kind of complex work I'd love to be a part of. You have to prove you've done the homework. You have to prove you want them, not just a job. The final 5 minutes are for your questions, and you must have questions. What's a typical day like? Is a terrible question. It's lazy. You need to ask something insightful that shows you're thinking like a future lawyer. I saw that the firm recently opened an office in Singapore. How has that impacted the workflow for junior associates on international deals? Or, what's the most common mistake you see summer associates make, and how can I avoid it? Then a bell rings. Time's up. You shake their hand, thank them for their time, and walk away, your heart pounding. You have 5 minutes to get to your next interview at a table on the other side of the ballroom, and you do it all over again, and again, and again, for 3 straight days. It is an Olympic-level marathon of smiling, nodding, and selling yourself. You eat, sleep, and breathe corporate law. You dream about the difference between a stock purchase and an asset purchase. The goal of this 20-minute sprint is not to get a job offer. The goal is to get a callback. A callback is an invitation to the second round of interviews. It's the golden ticket. It means the firm liked you enough to spend thousands of dollars to fly you to their city, put you up in a nice hotel, and have you spend a half day at their office meeting more lawyers. The callback offers start coming in during OCI week itself. Your phone, which you've been sneaking glances at between interviews, will buzz. It'll be a number from a New York area code. Your blood runs cold. You answer, trying to sound professional. Hello. And a voice on the other end, a recruiting coordinator, says, Hi, I'm calling from Sullivan & Cromwell. The partners you met with really enjoyed speaking with you, and we'd love to invite you to our offices for a callback interview. In that moment, a wave of relief so powerful it could bring you to your knees washes over you. You did it. You passed the first test. You're one step closer. But the gauntlet is far from over, because now you have to manage a schedule of callbacks in different cities, all while trying to keep up with your actual law school classes. And the callbacks themselves are a whole new level of pressure. You're no longer in a neutral hotel ballroom. You're on their turf. You're in their gleaming glass tower, surrounded by people who are smarter, richer, and more powerful than you can currently imagine. And you have to convince them you belong there. The 20-minute sprint is over. Now begins the half-day interrogation, where every move you make, every word you say, from the lunch with associates to the final interview with the hiring partner, is being scrutinized, analyzed, and judged. This is the real game. Forget your GPA, forget your law review title for a moment. This is the personality test. The can I stand to be trapped in a document review room with you for 72 hours straight? Test. It often starts with lunch. 2 or 3 junior associates, usually just a few years out of law school themselves, take you to a nice but not too nice restaurant near the office. They seem relaxed, friendly. They'll tell you to order whatever you want. This is your first mistake. Do not order whatever you want. You will order something clean. Something that doesn't require a bib or a team of surgeons to eat. Salmon. A chicken breast. A salad. Nothing with a dark sauce that can splash onto your tie. Nothing you have to eat with your hands. And absolutely under no circumstances do you order alcohol. Even if they do. Even if they insist. They are testing you. They want to see if you have the discipline, the self-awareness to understand the context. You are not their friend grabbing a beer. You are a candidate under a microscope. The conversation will feel casual. They'll ask about your hobbies, what you did last weekend, your favorite TV shows. They are mining for data. Are you a well-adjusted human being? Can you carry a conversation without being awkward? Or are you a socially inept robot who can only talk about the rule against perpetuities? Every answer you give is being filed away. You mention you like to run marathons? Good. That signals discipline and endurance. You mention your weekend was spent playing video games for 18 hours straight? Red flag. It signals something but not what they're looking for. This isn't about judging your hobbies. It's about assessing your ability to present a polished, professional, and relatable persona. They're building a profile of you, and that profile will be discussed the second you're out of earshot. After lunch, the gauntlet begins. You'll be led back to the gleaming marble-floored office and handed a schedule. It will be a list of names and times, a series of 20 or 30-minute interviews back to back to back. You will meet with a cross-section of the firm. A first-year associate, a fifth-year mid-level, a senior associate, and finally a partner. Each one serves a different purpose. The first-year associate is the relatability check. They were you a year ago. They want to know if you're going to be a cool person to work with on the low rungs of the ladder. They'll ask about your law school experience, why you're interested in their practice group. This is where you connect on a peer level. Show enthusiasm but not naivety. The mid-level associate is the substance check. This person is in the trenches. They're running deals, managing junior associates, and billing an obscene number of hours. They don't have time for fluff. They're going to grill you on your resume. That line about your corporate law journal note? They'll ask you to defend its thesis. That internship at the SEC? They'll ask you for your opinion on a recent piece of rulemaking. They are testing your intellectual horsepower and, more importantly, your genuine interest in the work. They can smell a phony a mile away. If you're just in it for the money, this is the person who will find out. Then comes the senior associate or junior partner. This is the career check. They're looking at you not as a summer associate, but as a potential long-term investment. They'll ask you the dreaded behavioral questions. Tell me about a time you had to work with a difficult team member. Describe a situation where you had to manage multiple competing deadlines. These aren't just questions. They are sophisticated simulations. They're not interested in the story itself. They're interested in the structure of your answer. Did you identify the problem? Did you articulate the steps you took to solve it? Did you reflect on the outcome and what you learned? They're testing your maturity, your problem-solving skills, and your executive function. This is where you prove you're not just a smart student, but a future professional who can handle pressure and complexity. And throughout this entire process, you must be doing something else. You must be interviewing them. The single biggest mistake a candidate can make is to not have good questions. At the end of each 20-minute slot, they will turn to you and say, "So what questions do you have for me?" If you say, "Nope, I think you've covered everything," you have failed. If you ask a generic question you could have Googled like, "What's the firm's culture like?" you have failed. Your questions are your opportunity to demonstrate your intelligence and your deep interest in that specific firm. They must be tailored. They must be insightful. You don't ask a first-year associate about the firm's 5-year strategic plan. You ask them, "What's been the most surprising part of the transition from law school to practicing here?" Or, "Could you describe the type of feedback and mentorship you've received on your first few assignments?" For the mid-level, you get more specific. I read in the Wall Street Journal about the firm's work on the Acme-Globex merger. I was wondering how a deal of that size impacts the day-to-day work of a mid-level associate. Are you involved in the high-level strategy, or more focused on the due diligence aspects? This shows you've done your homework. You're not just interested in a law firm. You're interested in their law firm and their work. For the partner, your question should be about the business and the future. Given the recent shifts in the global supply chain, how has the firm's M&A practice adapted to advise clients on new types of risk? Or, as an established leader, what do you see as the single biggest challenge and opportunity facing the firm in the next decade? This is how you transform from a supplicant asking for a job into a peer discussing the future of the industry. This is how you stand out. Finally, you'll be led into the largest, most intimidating office you've seen all day. This is the hiring partner. They may only have 15 minutes. They've already read the reports from everyone you've met. The lunch associates have weighed in on your social skills. The mid-level has assessed your intellect. The junior partner has judged your maturity. The hiring partner is here to make a gut check. They're looking for presence, for confidence, for that unteachable, indefinable quality that says, "Future leader." They might ask you a broad philosophical question. What does success look like to you? Or why should we choose you over the 50 other brilliant, qualified candidates we're seeing this week? There is no single right answer. They're looking at how you handle the pressure, how you think on your feet, how you articulate a vision for yourself that aligns with their firm's vision for itself. You sell them not on who you are now, but on who you will be in 5, 10, 15 years. You sell them on their return on investment. You walk out of that office, shake their hand, and the performance is over. You are escorted out, your head spinning, replaying every single word. But it's not quite over. You have one final test, the follow-up. You have 24 hours to send a personalized thank you email to every single person you interviewed with. Not a generic template. A specific, detailed email that references a particular point from your conversation. This proves you were listening. Proves you are diligent. It is your final argument in a day-long trial where you were the one being judged. And then you wait for the call that will change your life. And that waiting is a unique form of torment. Every time your phone buzzes, your heart leaps into your throat. You check your email 100 times an hour, hitting refresh as if your life depends on it, because in a way it does. You try to focus on your law school classes, but the words on the page blur together. Your friends are all going through the same thing, and you form a strange trauma bond, huddled together in the law library, comparing timelines, dissecting every word from every interview, trying to read tea leaves in the silence from the firms. Days can feel like weeks. You'll hear that someone got an offer from a firm you interviewed with, and a cold dread will wash over you. Does that mean you're out? Are they making calls in alphabetical order? By school? By the partner's preference? You have no idea. You are completely powerless, a passenger in the most important ride of your life. Then, one Tuesday afternoon, while you're spacing out in a secured transactions lecture, your phone vibrates. It's a number you don't recognize with a New York area code. This is it. Your adrenaline spikes. You grab your bag, trying not to sprint out of the classroom, and find a quiet corner in the hallway. Your hand is shaking as you answer. You try to sound calm, professional. Hello, this is. And the voice on the other end says it. The voice of the hiring partner you met last week. They make some small talk, ask how your week is going, and it's the most excruciating 60 seconds you've ever experienced. And then they say the words you've been dreaming of. Well, we were all incredibly impressed with you, and on behalf of the firm, I'd be delighted to extend you an offer to join our summer associate class. A tidal wave of relief crashes over you, so immense it almost brings you to your knees. You did it. All the grades, the late nights, the stress, the endless networking, the pressure. It all led to this single moment. You thank them profusely, trying to keep your voice from cracking. You tell them you're thrilled and that you'll review the materials. You hang up the phone and just stand there in the empty hallway, the sound of your own heartbeat roaring in your ears. You might let out a quiet yes under your breath, or you might just lean against the wall and laugh. The weight of the world has been lifted from your shoulders. A few days later, the official offer letter arrives in your inbox. And this is where the abstract dream of becoming a corporate lawyer becomes brutally, fantastically concrete. This is the first time you'll see the numbers that define the industry. Let's break down what's actually in that offer, because this is one of the most hidden and most important parts of the entire process. First, the salary. If you're getting an offer from a major corporate law firm, what they call big law, your salary is not going to be a negotiation. It's preset. This is determined by something called the Kravitz scale. Kravitz, Swaine & Moore is one of the oldest, most prestigious law firms in New York, and for decades, they have set the market rate for associate salaries. When Kravitz announces a pay raise for its associates, dozens of other elite firms, from New York to California, typically fall in line within days, sometimes hours, to match their scale. It is a show of force, a signal to the market and to potential recruits that they are in the top tier. So your offer letter will state a prorated salary for your 10-week summer internship, based on the annual salary for a first-year associate. As of late, that first-year salary has hovered around $225,000. Let that sink in. A 25-year-old fresh out of law school is offered a starting base salary of nearly $250,000. And the scale goes up every single year you stay at the firm. This lockstep system means you and every other first-year associate in your starting class will make the exact same amount. There is no haggling. There is no performance-based raise for your first several years. You are on a ladder and everyone climbs at the same pace. But that's just the base salary. The offer letter doesn't even mention the other massive component of your compensation, the year-end bonus. This is also largely determined by the market. At the end of the year, another market-leading firm will announce its bonus scale, and the race to match begins again. These bonuses are substantial, often ranging from $15,000 or $20,000 for first years to over $100,000 for senior associates. This bonus, however, is often tied to a crucial number, Your billable hours. Most firms have a minimum target, say 1950 or 2000 billable hours per year, that you must hit to be eligible for the full market bonus. This is the firm's way of ensuring you're putting in the work that justifies the extraordinary pay. And the money doesn't even start when you graduate. The offer contains hidden perks that make the deal even sweeter. They know you have to study for the bar exam for an entire summer after you graduate. You can't work during that time. So many firms will offer a bar stipend, a cash advance, often $10,000 to $20,000, just to cover your living expenses while you study. They will also pay directly for your bar prep course, which itself can cost thousands of dollars. If you're moving to a new city for the job, they'll often throw in a relocation allowance as well. So before you've even billed a single minute of your time, the firm might have already invested over $30,000 directly in you. This is the true cost of acquiring top legal talent. Now, if you played your cards right, you might not just get one of these calls. You might get 2 or 3 or more. And now you're faced with a new, wonderful, and terrifying problem. You have to choose. Since the salary and bonus at comparable firms will likely be identical, your decision has to be based on other factors. This is where all the diligence from your interviews pays off. Which firm had the strongest practice area in the field you're interested in? If you want to do high-stakes M&A, you look at the league tables and see who's closing the biggest deals. If you're interested in intellectual property litigation, you see which firm represents the biggest tech companies. But more than that, you have to consider the people. Where did you feel the most comfortable? Where did the conversations flow most naturally? You are going to be spending more time with these colleagues than with your own family. The cliché of firm culture is a cliché for a reason. It's real, and it will define your daily existence. Is the firm known for being a hard-charging, sharp-elbowed environment, or is it more collaborative and collegial? The only way to really know is to talk to people. Now that you have an offer, you have leverage. You can reach out to junior associates at the firms that gave you offers and ask for an honest conversation. Ask them what their worst day was like. Ask them what they do on a Saturday. Ask them what they would change about the firm if they could. Their answers will be more telling than any marketing brochure. You weigh the options, you make your lists of pros and cons, you trust your gut. And then you make the call and you send the email. You accept one offer and you politely decline the others. You print out the offer letter, sign it and send it back. It is a contract, a promise of a future you have worked relentlessly to secure. With that signed letter, the entire dynamic of your life changes. You are now a law student with a 6-figure job waiting for you. The intense, cutthroat pressure to get the best grades subsides. Your third and final year of law school, what's famously known as 3L, becomes a victory lap for many. You've already won the prize. But as the relief settles in, a new, distant cloud begins to form on the horizon. The job offer is contingent on 2 things: graduating from law school and passing the bar exam. You've conquered the firm. You've conquered the interview. But the final gatekeeper to the entire legal profession still awaits. And it is a beast all its own. The bar exam. It's not just a test. It's a rite of passage. A 2-day intellectual marathon designed to push you to the absolute brink of your mental and physical limits. Every single thing you've done for the last 3 years, every case you've briefed, every final you've stressed over, every networking event you've endured, it all comes down to this. The job offer, the 6-figure salary, the corner office dream. It's all provisional. The firm is betting on you, but the State Bar Association holds all the cards. Fail and the whole house of cards comes tumbling down. The moment you hand in your last law school final, there's no celebration. There's no vacation. You get maybe a weekend to catch your breath before you plunge into the most intense, isolating, and grueling academic experience of your life: bar preparation. This is the infamous bar summer. For 10 to 12 weeks, your life is not your own. It belongs to a commercial bar prep company like Barbary or Themis. You pay them thousands of dollars for a mountain of books that could anchor a small ship, and access to a meticulously planned out study schedule that becomes your new religion. Your day starts at 8 a.m. You sit down, not in a classroom but alone in your apartment or a library corral, and you press play on a pre-recorded lecture. For the next 4 to 5 hours you listen to a professor, an expert in their field, speedrun an entire semester's worth of law. Torts, contracts, constitutional law, criminal procedure, evidence, real property, the list goes on and on. You're not just relearning what you studied in law school. You're learning subjects you never even took, all boiled down to the black-letter law, the specific rules and exceptions you need to memorize. Hold. After the lecture, there's no break. You dive straight into practice questions. Hundreds of them. The Multi-State Bar Examination, or MBE, is the multiple-choice section, and its questions are legendary for their cruelty. They are dense, convoluted fact patterns designed to trick you, to make you second-guess the very foundations of the law you thought you knew. Every answer choice looks plausible. You spend your afternoons clicking through these, getting many wrong, and then spending hours reading the explanations, trying to rewire your brain to think like the bar examiners. Then comes the evening. This is for memorization and outlining. You're trying to cram an entire legal education into your short-term memory. You use flashcards, acronyms, mnemonics, any trick you can think of to remember the difference between the rule against perpetuities and the dormant commerce clause. You do this 6 days a week for 10 straight hours a day. Your world shrinks to the size of your desk. Your friends who aren't in law disappear. Your family doesn't understand the pressure. You are completely and utterly alone with the material. The mental toll is staggering. You develop something called bar brain, a state of perpetual anxiety and exhaustion where you start to see legal issues everywhere. You're at the grocery store and you start analyzing whether the wet floor sign provides adequate notice to prevent a negligence claim. You watch a movie and you're mentally drafting a motion to suppress the illegally obtained evidence. It's a sign the information is sinking in, but it's also a sign you're losing your mind. Self-doubt becomes your constant companion. One day you'll take a practice test and score well, and you'll feel a glimmer of hope. The next day your score will plummet, and you'll be convinced you're going to fail, that you're a fraud, that you'll have to call the partner at your firm and tell them you can't start in the fall. The stakes are so astronomically high that every mistake feels like a catastrophe. Then the day arrives. You fly to a massive, soulless convention center in a major city. You walk into a room with thousands of other aspiring lawyers, all with the same look of terrified exhaustion on their faces. The rules are draconian. You can only bring items in a clear plastic bag. No watches, no phones, no pencil cases. The proctors watch you like hawks. The atmosphere is thick with a collective, silent panic. Day 1 is the writing portion. It starts with the multi-state performance test, the MPT. They hand you a thick packet of paper. Inside is a simulated case file, interoffice memos, client letters, witness depositions, and a small library of fake statutes and case law. Your task is to act as a lawyer and draft a legal document, like a persuasive brief or an objective memo, based only on the materials provided. You have 90 minutes. It's a frantic race against time, testing not what you've memorized, but whether you can actually think, analyze, and write like a lawyer under immense pressure. After a short lunch, you're back for the essays. The Multi-State Essay Examination, or ME. 6 essays in 3 hours. 30 minutes per essay. A question will pop up on a subject you haven't thought about in weeks. It could be anything from family law to trusts and estates to secured transactions. You have to spot the issues, recite the relevant legal rules from memory, apply them to the facts, and reach a conclusion, all in a few short paragraphs. You write until your fingers cramp, your brain churning, praying you're not missing the key issue that's worth all the points. You leave day 1 feeling like you've been intellectually pummeled. You try to get some sleep, but your mind is racing, replaying every mistake you think you made. But there's no time to dwell, because day 2 is the beast itself, the MBE. 200 multiple-choice questions, split into a 3-hour morning session and a 3-hour afternoon session. This is a test of pure endurance. By question 50, your brain is already tired. By question 150, you're running on fumes. Every question is a new mental puzzle, a new trap to avoid. You finish, hand in your booklet, and walk out of the convention center into the sunlight, a completely hollowed-out version of your former self. It's over. But the torture has just entered a new phase, the waiting. Jurisdictions take months to release the results. For 8 to 12 weeks, you exist in a state of suspended animation. Your job offer is pending. Your entire future is a question mark. You can't study anymore, but you can't relax either. Every time your phone buzzes with an email, your heart leaps into your throat. It's a unique and exquisite form of psychological torment. Then one day the email arrives. The subject line reads, "Bar exam results." This is it. You take a deep breath. Your hands are shaking as you click the link and log in. You scroll down the page, your eyes searching for one word. And then you see it. Congratulations, you have passed the bar examination. The feeling is impossible to describe. It's not just happiness. It's a tidal wave of relief so profound it feels like a physical weight has been lifted off your soul. It's the validation of 3 years of law school, of a summer of hell, of a decade of relentless ambition. You made it. But hold on. There's one final hidden gatekeeper. Passing the exam isn't enough. You also have to pass the character and fitness investigation. This is where the state bar becomes your personal biographer. They scrutinize every corner of your life. They pull your credit report, your driving record, and your criminal history. You have to disclose every address you've lived at, every job you've ever had. You have to explain that $30 late fee on a credit card from 7 years ago. You have to account for that speeding ticket you got in college. Any hint of dishonesty, financial irresponsibility, or untrustworthiness can derail your application, even after you've passed the bar. It's the state's final check to ensure that you not only have the brains to be a lawyer, but the moral character as well. Once you clear character and fitness, the final step awaits: the swearing-in ceremony. You stand in a courtroom, often before a panel of judges, surrounded by your family and fellow new attorneys. You raise your right hand and you take an oath. An oath to support the Constitution of the United States and of your state. An oath to conduct yourself with integrity and civility. In that moment, the transformation is complete. You are no longer a law student. You are no longer a candidate. You are an attorney, an esquire, a member of the bar. From that first diagnostic LSAT to this final oath, the path has been a relentless, unforgiving climb. It has demanded a level of sacrifice and dedication that few other professions require. It's a journey that tests your intellect, your endurance, your finances, and your spirit. It is designed to weed people out at every single stage. But for those who navigate the maze, who conquer the exams, and who survive the trials, the journey is finally over. And a new one, as a corporate lawyer in the United States, is just about to begin.